We're glad you're here. Thank you for coming. I think Mandy usually has something to say about where things are at this point.
Hello, good evening. Thank you all very much for being here. My name is Mandy, and I just wanted to run by a few quick things before we start. Wanted to let you or remind everyone where the exits are. Actually, for us in an emergency, we would leave right through that back door where the exit sign is. You might have noticed restrooms are just outside our door off to the left. And I usually make an announcement about the fact that we always bring toys to the meetings just in case we have kids here. We, as you might know, we live stream this meeting, and we also broadcast this on television. So for everyone here tonight, but also for people who are watching this evening, I wanted to make sure everyone knew we do offer childcare upon request. And it takes us a little time to arrange that with an outside agency. So we ask that if you would like to have childcare present, so you can be here if you have kids, to get in touch with me 10 days in advance so that I can schedule it. So if you are watching this at home tonight and you're not here because you have children and didn't know if you would be able to make all of that work, please know we'd love to have you here. I have cards outside with my contact information for anyone here if you want to share that with your friends, or if you yourself would like to bring kids. And if you are watching at home, just know that you can call me, and my phone number is 503-823-5149, and we are happy to help arrange childcare so that you can be here with us. And that's it.
Thank you. To let you know, Senator Gordley and Laquita Lanford will not be here tonight. Rabbi Kahana will be late, and Catherine Gardner is on the phone, and she will be voting from wherever she is with the phone. Okay. Oh, and Alicia is not here tonight. Thank you. Okay. The other people may show up at some point. So tonight is mostly going through the recommendations from the Use of Force Committee. And to let you know, after each proposal, there will be time for public comment. But I will be limiting the comment, no more than 3 minutes. I think the sheets are outside if they have been signed up. Have you signed up for, Mandy, are the sheets out on the table?
They are, yes.
So if you want to sign up for a particular recommendation, please get your name on that list. They'll be brought into me soon. On the general public comment, time is now. If there are things that people would like to say just generally to the COAB, now is the time. I think somebody took my timer, which is my phone. Here it is. I can use this. All right. Anybody want to make a general public comment at this point? Is that your hand up, Dan?
Well, if there's not another general comment later, then I hope I should.
Go ahead. You got your 3 minutes.
There's a microphone back there.
Well, yeah, there are other people. There are 3 people signed up.
Okay. Good evening, COAB members. I'm Dan Handelman with Portland Cop Watch. I don't have extra copies of our newsletter with me tonight, so if you didn't get one last time, I'm sorry. I only have 1 or 2 left with me. Today, the City Council heard from the OIR group, which studies police shootings and deaths in custody that happen in Portland. And the chief initially wrote a 1-page response saying, I generally agree with what you're saying. But then he provided a line-by-line response to all 31 of their recommendations. And I know that's a sore point for us at CopWatch and for you, the COAB, that you're not getting line-by-line feedback on your recommendations. I just want you to know that he does do it for this group, so it's possible, and I'm hoping there's no reason for the discrepancy. The report is very important. I sent all of you whose email addresses I have a copy of what we wrote. I hope you had time to look through it, at least the short version of it. There are a lot of issues that didn't get caught in the investigations, including actions by the supervisors, including actions where the officers put themselves in a position where they ended up using deadly force, that technically by doing that, they were out of policy, but they weren't found out of policy. And particularly for the accountability subcommittee, this means that a person who has a finding where the police were in policy can't appeal that finding to the Citizen Review Committee, and so we're stuck with the finding that they had, even though we now know by reading this report that the officer should have been found out of policy. So we have to change our system, we have to change the way that the investigations are done. There was also another report that came out just a week before that. It's the Police Review Board report, and the Police Review Board is another body that you actually haven't really had a time to talk about here, the internal body that reviews shootings and deaths, and when an officer is being proposed to be found out of policy for some reason. And those meetings of the board are closed to the public. The reports about the shootings in there are very short and so lacking detail that we couldn't even tell for sure which one of the shootings was, because all it says the officers faced a situation where they thought their lives were in danger and they used deadly force, which could apply to any incident in theory. So we had to guess. I think we guessed right, because public information officer corrected us about something else, but not that. So I'd really encourage you to look to, I know you all have a lot of stacks and stacks of things to read, but to the extent possible to look at least on our website for the analysis that we're doing about these things, which is a lot shorter than the 120-page documents that are coming out. But please feel free to ask me questions about these things if you want to know more information. Thanks.
Thanks, Dan. Kip Davis.
So I'm David Keefe Davis from Multnomah County Cop Watch, and I also work with a group called Fight the Sweeps Portland, which monitor homeless sweeps and record homeless sweeps. But last time I testified about being arrested for filming at City Hall, and I was filming a mentally ill guy in crisis, Barry Joe Stull, and he's still currently in jail. And Amanda Fritz is a trained psychiatric nurse. She was the only person that was at the City Hall in the council chambers at the time. Barry Joe Stull called for medical assistance probably 20 to 30 times. Instead, the police showed up, and Amanda Fritz ordered the clearing of the council chambers so the public could not witness what went on with the abusive police officer, Todd Angstrom, who's choked service dogs and maced homeless people under the Morrison Street Bridge, which might be one of the people that Dan Handelman was actually talking about when he mentioned the police escalating things and basically being called out for that, but not disciplined. So, you know, there's a lot of escalation that goes on amongst the police. And Kathleen Sadat, you actually said last week, or 2 weeks ago when I was testifying, that my testimony wasn't relevant to COAB and that I should stay on topic of what you guys are doing. So I don't see how you can even say that to me. And if you think that my comments aren't relevant to what COAB's doing, maybe you're actually not relevant to what COAB's doing if you can't do the basic math on that, you know? Because we're talking about a mentally ill guy in crisis mode that gets the police called on him by a trained psychiatric nurse who's one of the 5 cocktail liberals, as Joe Walsh calls them, that runs this little city. And I see a lot of gatekeeping going on in this whole COAB thing, and not a lot of work.
Keith, You're violating our ground rules right now by devolving into personal attacks on Kathleen. So personally, one-on-one, I'd like to ask you to try and avoid that if you could.
I'm actually
Time is up.
talking about something that's very relevant when someone says that my testimony about mentally ill people being treated wrongly by the police that are still rotting in jail, maybe, you know, you need to do the basic math on that one too, bud.
The time is up. Keith? Nancy Newell?
I support all the work that's been done that's fabulous on photojournalism on the homeless. There isn't much out there that's protecting people out in the streets. They're traumatized, under stress, in totally wet conditions, freezing conditions. And whatever we can do to improve relations within COAB should be one of the key issues in the city. And housing, of course, is something that the mayor is suggesting the next round, which certainly would help a lot of it. But right now, the situation is tragic, and the behavior of the police not up to speed. So I think we can do a lot of work here and get results. Thanks.
Thank you. Anyone else?
I have something. It's Philip.
Okay, Phil.
Hi, everyone. Welcome the community members for attending here this evening. And I just want to make a real brief announcement. Decided to go ahead and step down out of the Use of Force Committee. I am going to attend now the Accountability Committee. And so I have joined in the Accountability Committee with the DSUFCS opportunity. I really appreciated the teamwork, and I'm disappointed. I'll miss everyone, but I still will be involved, and I still continue to support that committee. So thank you.
Thank you, Philip.
I have a follow-up comment to what Dan talked about. May I go ahead?
Go ahead, yeah.
The COAB passed a recommendation a few months ago for the elimination of the 48-hour rule. And since then, a couple of things have happened, which I think are noteworthy. I'm not sure whether our recommendation had anything to do with it, but hopefully it was a piece of the puzzle. The union that represents approximately 40 lieutenants has just agreed in collective bargaining to the elimination of the 48-hour rule in their contract with the city. Secondly, Ann mentioned the OIR Group's report, and one of its recommendations, which it has made repeatedly over the past several years, is that the PPA as well, which is the union that represents the bulk of the officers, officers on the street and sergeants, also eliminate the 48-hour rule. And I would, again, urge the city, I would urge anyone in the Bureau to reconsider their position regarding the elimination of that 48-hour rule, given the helpful position being taken by the lieutenants and the report again by the OIR group.
Thank you, Tom. Any other comments?
I have a really quick one.
Okay.
So I just want, I want the community to know that I've decided to switch from the mental health crisis response subcommittee to the data systems use of force subcommittee, especially in light of the important information that our community partners bring to us about current events that are occurring specifically with a highly marginalized group, the homeless people and the sweeps. So I'll be looking forward to working with that committee again. Thank you, Keith, Nancy, Dan.
Thank you, B. Any other comments? Okay. Most of this evening is scheduled to be to address the recommendations out of the Use of Force Committee, and they should be on your agenda. The summary statements for the recommendations themselves should be on your agenda. So I'm going to let Tom manage most of this since they came out of your committee, Tom.
This is the third time I think we've tried to address these recommendations. At the meeting in December, the first 4 of the 8 recommendations on Directive 1010, which is the primary use of force recommendation, were approved by the COAB. Briefly, the first one had to do with a complete review and rewrite of that directive and other use of force directives. The second had to do with the approval of a set of core principles. The third had to do with a clear standard for the determination of what would be reasonable force under the Bureau's policy. And the fourth had to do with deadly force. Again, just as a reminder, the Data System Use of Force Compliance Subcommittee reached these recommendations after reviewing best practices, particularly those from the City of New Orleans and the City of Seattle, both jurisdictions where the Department of Justice has sued over pattern and practices of excessive force, and where they have approved policies which the subcommittee then incorporated in their recommendations. And I just want to thank the COAB for its attention and approval of those first 4 ones. So there's 4 more we need to get to, and then there's another set, if time permits, of 9 recommendations on other use of force related directives, such as, just as a couple of examples, tasers and beanbag shotguns. Last time, Kathleen, you read into the record the particular recommendations. Do you want to continue to do that? Okay, we're on the 5th one then.
This is 102215-5, specific prohibitions on the use of force. Prohibitions against the use of specific types of force should be explicitly spelled out, both for absolute prohibitions and prohibitions except in very limited circumstances. Do you want to comment on that, Tom?
Again, the premise is unfortunately, the current policy is not clear and it's not complete and inclusive as to prohibitions. And when you look at best practices, what people do, and it makes sense, is they are very careful to lay out in explicit form prohibitions, some of which are absolute. You're just not going to do it at all. And other times you might get to use the force, but under very limited circumstances. And that's what we've tried to do, is set up a format. And again, let me remind people that we are not writing policy. We don't intend to have this be a final document as to what ultimately the Bureau and or the Department of Justice in collaboration will come up with as a policy. We're not policy writers, but we have tried, again, in this particular recommendation, as in the previous ones and in the additional ones, to lay out really important guiding principles which we think need to be included. So again, these are not necessarily complete policies. We're not suggesting there aren't provisions of existing policy that aren't good and may need to be included. But we want to be clear on what we think needs to be in. Good.
Just to make sure you know, there's a packet here. The cover says recommendation submitted for full COAB vote, and it starts with 102215-5, and that's what we're looking at. Okay? So is there any public comment on this particular recommendation? Dan, go ahead.
Hi again. I'm still Dan Handelman. So I actually handed most of you some comments back in the December 10th meeting. I have more copies here if you don't have them still, but particular to this recommendation, in section B, it talks about officers can't use force unless somebody verbally impedes a legitimate law enforcement function or contains specific threats to harm the officers or others. So our comment was that this has serious free speech implications, the way it's written, verbalizing objections to officers' commands, asking officers to leave, or advising other community members of their rights should not be reasons to use force. There are some, there's a list that's sort of like that in the new directive that just is up for review this month. It's what we call the cop watching directive, and it's a brand new directive that never existed before to allow citizens, community members, be more clear, to observe the police, and they have some distinctions in there about what's interfering, but again, it's not specific enough and not clear enough. So I'm hoping that you make sure that the Bureau doesn't leave things too vague in this directive because it involves force. Thank you.
Thank you, Dan. Is there any? Kip, are you up on this one?
Yeah.
Is your name pronounced Kip?
It's actually Keith Davis, K-I-F, Keith Davis.
All
It's
right.
a Moroccan name. But I wanted to kind of back up what Dan said because I've actually had the police use force on me multiple times for simply filming homeless sweeps or other activities with the police, including Mr. Leo Besner, the sniper rifle cop who shot the guy in the back and who's cost the city over $1 million so far. He actually just attacked me last week and put his hands on me when I was filming a homeless sweep. You can go to fightthesweepspdx.com. And
Can you help us out by talking about the recommendation a little more and what you'd like to see happen with that?
I basically would like to see you guys tell the police that they can't just...
He is saying that he shouldn't be attacked for simply filming the homeless sweeps.
Yeah.
He has the right to film.
Just a minute.
And
Just a
yeah,
minute.
I
Philip,
think that's his
Philip,
point. being
just a
added there.
minute, please. I'm asking him to give us some help. I've asked him for some help. And he was
That's
doing,
what I'm
he was
doing
that.
now.
Yeah, he was doing that.
And Philip is right, because that's what I'm talking about, is being attacked by crazy cops that have already cost the city over $1 million, like Leo Besner. I've been attacked by him twice in the last 6 months or so for filming homeless sweeps. And I filed a complaint against him, and I plan on filing another complaint against him because, you know, when you order someone to leave the area or you can't film here, that's one thing, and I can comply with orders without being, you know, manhandled by the police. The last time Leo Besner grabbed me, he actually drew blood on me, and now I refer to him as Officer Pig Claws, actually, because he's likes to put his little pig claws on people, you know? And I'm getting real sick of this. And, you know, Dan's talking about this new bill that's supposed to protect people like me and other citizens that go out and film the police. You guys need to recommend to the police that they stop interfering with journalists. I got an interference charge, actually, just a couple weeks ago on January 7th, I believe. And I wasn't interfering, I was filming, and I was asking questions. And
Time's up. Mr. Davis, your time is up.
Yep, if you look at the definition of interference, it doesn't include speech.
Mr. Davis, I want to remind you that we try to keep a civil tone in our meetings, and that means no name calling and not assigning to people negative characteristics. We'd appreciate it if you'd keep with that guideline. Thank you.
So I can't call him Officer Pigclaw?
We would prefer that you not.
Strongly.
I kind of like that nickname.
Your time is up, sir. Discussion on the COAB, please.
Kathy, I'm a little unclear. You didn't read the entire recommendation. Was it your intent to do that, or do you want me to talk about it?
Well, I assume, okay. Do you want?
Last time, that's what you did. I just don't know what you
You
want.
know, I've got this summary, then I've got pages and pages. So if you want me to read the whole thing, I will. read it.
I'm not asking you to do that. I don't know whether if you're not going to do that, let me comment on it.
I was expecting you to comment
All
on
right.
it, Tom, because there is quite a bit here.
All right. I'm not going to go through every specific recommendation. I want to highlight the two where there has been some opposition. I think it's fair to say, but I can be corrected, that there has really not been any opposition. And when I talk about opposition, it's from the police advisors as to two. And the first one is Section D. Section D says intentional strikes to the head, neck, throat, heart, kidney, groin, and spine with any authorized impact weapon, such as a baton, or with an officer's feet, knees, fists, and elbows can be deadly force. Therefore, such intentional strikes are prohibited except when under the facts and circumstances deadly force is authorized. More or less, the current policy prohibits impact strikes with batons to the head, as an example, without justification for using deadly force. Other jurisdictions have broadened the areas, as have some of the experts who have consulted with the city, to include other sensitive areas that can result in death or very serious injury. And those are the body parts that we've identified. The opposition is that there's concern by advisors that the officer's feet, knees, fists, and elbows should not be included. The reason the subcommittee included those is that it is our understanding that kicking somebody in the head with a boot is as likely, or potentially as likely, to cause death as using a baton. And so we included the officer's personal body parts essentially as another form of an impact weapon, because it can result in the same kind of either serious injury or death. And the police advisors have wanted that not to be included. Is that fair?
Partly, but majority no.
Do you want to comment, or?
Sure. When I look at that recommendation and I look at where he says that the recommendations incorporate best practices and cites Seattle as well as New Orleans, unfortunately that's a misrepresentation of the truth and of the facts. That is not what they teach. That is not what they do. And then to make sure of that, I actually spoke with a sergeant from the train division of New Orleans today, as well as an officer from Seattle. They don't. An impact weapon is something that you pick up. It is not your body parts. It's not your body. It's something you pick up. Now, where I said partly I do agree is that, yes, a kick to the head absolutely could cause deadly results. And yes, that would be looked at under the totality of circumstances is the way that we look at things, and we've talked about this numerous times. You know, where I don't agree with this is let's say it's a 5'1", 120-pound female officer, and it's a 6'4", 280-pound suspect. If she punches him in the kidney, is that going to be considered deadly force? According to this policy, it would be. Okay. Now, let's flip that. It's an officer that's that large and a suspect that is not. Would that be considered deadly force? Yes, it could be under the totality of the circumstances. And again, the Supreme Court is very clear when it comes to force and have overruled multiple courts that, no, you have to look at the totality of the circumstances. And again, making a broad brush blanket statement over things like this absolute prohibitions, I think, is dangerous not only to officers, but to the community members also. So no, so partly yes, I agree, and partly no, I don't agree. It does not, again, there's a lot of misrepresentation of fact and truth in this, and that concerns me.
I got a quick question for Paul. So I'm just a regular citizen, you know that. I don't know anything about the law or anything like that. So what I keep hearing is totality of circumstances. And then I go back and I'm thinking about what Tom and what D is actually, the spirit of D. It seems to me, it appears to me, it's apparent to me that it's talking about the impact that some force, whatever it is in terms of a spectrum, has on a potential victim. So, for instance, one of the things I think, regardless of the size of the officer or the person in question, what if you have something like a neck bag? It doesn't seem like you would really cause a lot of harm to the neck, you know, with the neck bag. It's not a baton, but still.
Not sure what that is, I'm sorry.
Just let me finish.
Okay.
But still, the impact that it has is to cause harm to then the victim. You know what I mean? Does that make sense?
I'm not sure what a neck bag, is that what you were saying? I'm not sure what that is.
Well, you know, I'm not a police officer, but I was hoping maybe you guys, you guys don't use a neck bag on the force?
Neck bag?
I don't even know what that is.
No.
Can you describe it?
Big bag, but
What's that?
It's like
Can you repeat that?
there's like it's a mask that you can put over somebody that allows breathing and everything else, but just doesn't allow them to spit. But it's not a force thing. It's just to keep them from spitting on anybody. I'm not sure what a neck bag is, though, for force-wise. I'm sorry.
No. That's just something that I heard from a community member, and they showed me pictures, and it looked like this guy had been strangled.
Not sure what
I mean,
that
there
is.
were
I'm
visible
sorry.
marks around his
Okay,
neck.
so
You know,
Yeah.
well, there's some disparity between what happens, what you know, and what happened to the community member, and obviously my layman's knowledge. Right?
So
It seems to
can
me
we-
the spirit is, it's about the impact on the person.
Dr. Mirren.
I just want to weigh in again. I think that some of these descriptions are in fact limiting, and the legal standard does seem to be a reasonable person regular language standard to, in my opinion. Totality of the circumstances does take into account all of the circumstances surrounding what happened. And so it could take into account if it was the smaller officer and the larger victim, or vice versa. And so to me, that is more inclusive and seems like it would be more protective than setting out a list of things that don't necessarily fit the real world. We can't have an all-inclusive list. Therefore, I would argue for the broader totality of circumstances measure. I think that's more protective to people, and is a just fairer way to approach the standard.
Rochelle and Phil?
I think one of the problems with that is sometimes there's only one person left after the incident. One person's dead, and then there's the police person. And the police person gets to write the report and use whatever totality of circumstances are in their mind, but not necessarily in the mind of the victim or the dead person. And so it becomes a one-sided affair sometimes.
And I totally get that. Actually, that's very helpful. I agree with that. I do think in cases where there's use of deadly force, there will be some objective finding that there's a bruise somewhere. I mean, just that there will be some finding that adds into the totality of circumstances, like, well, there's a bruise to their flank where they were kicked in the kidney, and whatever it was. So I think if it gets to the point where a person, would be unable to speak for themselves, that the totality of circumstances would give some additional objective findings that improper behavior happened. But I do get what you're saying, so I appreciate that.
Philip?
Yes. I wanted to just point out something real quick about the deadly force and use of the impact to a head, or use of a knee impacting the head, or an elbow or whatever. And exactly what we were talking about, the size of the victim and size of the officer, I think really doesn't come into play. I think it's who's pledged themselves to serve the community. It's about the people and the relationships, and it's being escalated. And I don't know why we would want to make anything allowed and permitted. It is important to specify what's prohibited, because we can use the totality of circumstances as a reason to escalate. And I think that it's a reason that an officer can use in any situation against the victim. So maybe I should suggest more verbal warnings, or even de-escalation efforts. Back off of the situation. If there's the use of an elbow to the neck, just like Dr. Rochelle was saying, they can use any excuse or explanation of what happened that they want to. And so I feel like we should prohibit these impacts and body parts for the use of force.
Bud, Rabbi Kahana, Tom, and Tasha.
So a quick clarifying question for Paul, and then this will most likely redirect to Tom. In what you said, I think I heard you saying that what we considered in this recommendation in DSUFCS, which had been the statement that this is a policy change that would bring us into line with policies in Seattle and New Orleans. I think I hear you saying that you're bringing new information that we didn't have in DSUFCS that refutes that. Is that correct?
Really, no. Really, no. If you look at the area, there's a cons section under D in the handout that we've all received. And in that section, and this was the ones that I provided back in, I think, October, November, it says the recommendation is wrong. It doesn't actually represent Seattle or New Orleans or the other two agencies that were referred to at the time, Las Vegas and Denver. So even back months and months ago, I had mentioned that it does not have that language, and neither do any of the other agencies. And I also looked at their policies, and in one of them, in New Orleans, it talks about solid or semi-solid objects. So I asked the New Orleans training sergeant, what's a semi-solid object in your mind? It would be something like a radio or a gun, or something that's not solid, like a piece of wood or a piece of metal. It's not a fist, it's not a hand, it's not a knee. Mr. Wolf had talked also about the head. And again, I am also with you that a hit to the head is more likely to cause potential injury than hits to these other areas. But it's not just the head that's listed in here, it's all sorts of areas that are. And again, and then to speak to Mrs. Silver's, Dr. Silver's recommendations that, if there's only one person that's left, and if there's somebody dead, the level of review is at the minimum going to be 9 or 10 different places, and at least 3 or 4 to be completely separate of the police bureau. So the level of review is going to be extensive, including an autopsy, as Dr. Miriam mentioned. So it's not just as easy as just one person. There's going to be a large review being done on many different levels.
So, Paul, I just want to verify my correct understanding of what you just said, because this is very important to my vote. I hear you saying that these conversations that you had relating to New Orleans and Seattle took place prior to deliberation in DSUFCS, and that you brought that information to DSUFCS for consideration. So we're not introducing anything new at this point. Is that a correct statement?
The only thing new would be the conversations that I had today with the officers and sergeants from both agencies.
That's what I was asking.
But, so yeah, again, the conversations that I had today only confirmed the information that I submitted back in, I think, October.
So
That's all
essentially
that
no
it
new
did.
information.
All right.
Okay.
That answers my question. Thanks, Paul.
Rebecca Hanna.
Thank you. I just one preliminary question. There's some non-substantive grammatical issues. Can we present those offline? Okay. Thank you. It seems to me that this issue has to do with the first word, intentional, and we're dealing with unintended consequences of intentional actions. The officer in question's goal is not to cause death or primary injury. It is an unintended consequence of that, which seems that it could. It's a bit of an odd statement because there are all kinds of things that could cause unintentional consequences. Someone can trip and fall, hit their head, and something could happen. It seems like the focus here was on the issue of impact weapons, and so it does seem a little bit odd to suddenly add any kind of impact that's involved there. We're prohibiting an officer from protecting themselves if they are in a fight for whatever reason. This seems to be very specific into there's almost nothing left that they can do, that concerns me a great deal. That's very different to me than many of the other things that are on this page. I would like to ask, the only recommendation that I'm seeing for alternate language is the removal of officers' feet, knees, fists, and elbows. Is that the recommendation for an alternative text, or is there another recommendation?
I have not heard another one. Tom?
2 comments. There has been no misrepresentation by the subcommittee as to what other jurisdictions have done. We relied upon Seattle, and what it says is this: the head, throat, neck, spine, groin, or kidneys shall not be targeted unless deadly force is justified. So we didn't make up the other body parts, the other areas, the sensitive areas. It's in another policy, and it's similar in New Orleans. What we did do, and it's been clear from day one in the subcommittee, and no one hid this from the police advisors, we felt, after asking the police advisors, that just as much harm could be done using a body part, the officer's boot or the officer's elbow, as a baton. And we felt it made sense to then add that for the protection of people like you and I. One other comment. In terms of what Rochelle talked about and what Sharon talked about, the best example where the totality of circumstances didn't do a thing in terms of protecting someone is that James Chassie suffered 19 fractured bones, 23 fractures in total. It was documented in the autopsy, and not a single officer, despite the witnesses describing the beating that he took, including being kicked and slugged, and there was no baton used, not a single officer was subjected to any discipline for that use of force. So the totality of circumstances language I would suggest is not very limiting, and that's why, in part, the subcommittee felt that adding very specific language to protect people from unnecessary uses of force. If it's a deadly force situation, then you can use deadly force. That's not what the recommendation says. But unless deadly force is justified, you can't hit somebody in the head with an impact weapon, a baton, and we don't think you should be able to hit them in the head with a boot or an elbow or a knee, because you can cause someone's death the same way.
Tasha?
So what I want to really kind of address, actually just a couple of things. The first is the fact that I happen to be a 5'4" female police officer. And what I'm going to say is that if you were to tell me that I could not use any of my body parts, what would end up happening is I would have to use a tool. And the likelihood is that tool would be a gun. So because I as much as I know people think that we should accept the fact that we're going to die in our job, that's not actually true. I signed on to protect people, but not to go to work and die. So if I end up in a physical altercation and I can't protect myself by using my hands or my knees or my elbows, and I'm losing a battle, I'm going to end up using a gun because I'll be in a deadly force situation. So this is not a good, that particular piece is not a good policy. It's not safe for me, and it's certainly not safe for the community. The second piece is an understanding about totality of the circumstances. It's a legal standard. It's a legal standard, and our policy is already more restrictive than the legal standard, but they run two different things. Policy is about keeping your job. The legal standard is about going to jail or getting sued. So kind of being able to draw a little bit of a line between those two is understanding those standards. The standard of force can be more restrictive, and ours is, than the legal standard. But I still have to be able to protect myself because I do want to go home at night. I mean, that's where this is at. So, and to the comment about a fist and a baton, I'm going to tell you, I mean, this is the size of my fist. I will guarantee you I could punch a bag as hard as I could, and it will not have the pound strength that swinging an asp or a stick will have. They will never match between my fist and a baton. Now, that might be different for some police officer who's 6'2" and 240 pounds. Might be different for him, but this policy is going to apply to him and me the same. So there has to be some way that this policy addresses that, and that's the reasonable standard.
Paul, and then Rochelle.
A couple things with Mr. Steenson brought up. He mentioned that there was no misrepresentation, and he read part from Seattle's
Paul,
lesson plan.
I want to stop the "you're wrong, you're right" piece, because we don't have any way to evaluate that, except you two saying say that. So give me something concrete, please.
Okay, so in the packet that was handed out, that he read from, that says that those target areas will not be used, is under the impact weapons area. And Seattle Police Department does not view your hands, feet, and fists in that section with this. It's talking about impact weapons, and when it looks at approved impact weapons, it's not those things that are listed in here. So that's incorrect, unfortunately, what he mentioned again. And again, I think with any of this, what we have to look at is what is the likelihood of it to cause death? Whatever force that is used, what is the likelihood of it to cause serious injury or death? And that's how we have to look at it. If I knee somebody in the groin, is it likely to cause somebody to die? More likely than not. So just say 51 out of 100. Is it likely to kill somebody? If I'm in a bear hug and a huge guy has him wrapped around me kneeing him in the groin to try to break free, is that likely to kill him or seriously injure him? If I throw a punch as hard as I can in his kidney, is it likely to kill him or seriously injure him? That's what we have to look at, and that's what the totality of the circumstances looks at. Again, following the United States Supreme Court ruling, which they have had 1989, so that many decades of established case law where they haven't changed it, and they've had opportunities to do that.
Okay, thank you, Paul. Michelle?
I think that maybe people aren't reading what this says here because nobody on the committee wants you not to be able to protect yourself in a deadly force situation, and that's exactly what it says. It says that such intentional strikes with the feet, knees, fists, elbows can be used when the facts and circumstances are saying deadly force is in play. What we're saying is when deadly force is not in play, that these strikes should be prohibited. So if you're in a fight for your life, go ahead and use your knee or whatever you got to use. If you're in a fight for your life. But if it's not that, then you don't need to kick a person in the head.
Okay, Tosh, and then Sharon, did you have a hand up? Yeah. And then we're going to move on.
Okay, so to be clear, what I'm talking about is prior to something escalating to the point where I would feel deadly force was necessary. And what I'm saying is, if I'm restricted in getting to that point and I get to a deadly force situation, you may say at that point you can use your fist, but at that point, if it's deadly force, it may be a gun that I'm using, because who knows what situation that I've gotten into at this point. So if I can resolve a situation earlier by using my fist, and that's the level of force I get to, and that's it. And like Paul said, not everywhere you hit is there a likelihood of death or serious physical injury, and the incident is over, then I haven't allowed it to escalate. But if I don't have that option, then what is the option? Allow it to escalate? Because that's in my vision, that is what I see. These incidents will continue to escalate because there will be no capacity to end them earlier.
Okay, Sharon, and then Michelle, and then we're gonna, no, Michelle, not Michelle.
I just was going to say what Tasha said about that use of other types of force may prevent escalation to a need for use of deadly force. So that, and I also agree with Officer Paul that a lot of these are unlikely to be deadly force. I mean, just from the punch in the groin, a kick in the groin, uncomfortable, but usually not deadly force.
Michelle.
Well, yeah, just to kind of feed off of what Sharon had said and Tasha and Paul a little bit too is, you look at this is, and I'm reading this like our human body is a dangerous weapon. And if you look at the Oregon Revised Statutes, it's not defined that way. The human body is not considered a dangerous weapon. It's not a weapon, a device, an instrument, a substance, or material. When you're talking about a dangerous weapon, you're talking about a baton or something that's detached from you. So even from an investigative standpoint, yes, it's going to have to be looked at from a reasonable standard, not just, a punch to the face being considered automatically deadly force, because by definition, the human body is not considered a dangerous weapon.
Okay, I want to start to wrap this up and do something else with it, Sharon.
Impact.
I was just saying I would like to wrap this up and do something else.
Yeah. Rebecca
So
Hanna.
I would move that.
Go ahead. You have the mic. Make the motion.
I was going to. My motion would be. I mean, I support the vast majority of this. I mean, so my motion would be to. I'm not sure how to frame this motion. to accept
Well,
without, okay,
hold on.
yeah.
Remember, Tom said there are 2 points of disagreement within the recommendation. I think this is just the first one. Am I correct, Tom?
Okay.
Yes.
Okay.
The second area where there was opposition from the police advisors had to do with Section H. It says the use of neck holds, choke holds, and carotid holds. This is an absolute prohibition. The Police Bureau does not teach the use of neck holds, choke holds, or carotid holds. In fact, when Lloyd Stevenson was killed with a carotid hold in 1985, the Bureau took the position that it was banning the use of the carotid hold. It doesn't teach the use of any form of a neck hold. I've asked the police advisors, and from anecdotal knowledge, I'm not aware of any time that an officer has used that form of deadly force since 1985 in this city. And since it isn't taught and it's deadly, we, as the subcommittee voted, believe it ought to be an absolute prohibition.
So you have 2 absolute prohibitions here. One is the chokeholds, carotid holds. The other is the hog ties, which I think...
That's not an issue.
Okay, yeah, I thought it had already been taken care of. All right, so now, Sharon, you were about to formulate a proposal, a friendly amendment. Oh, I'm sorry, let's go back. Are there any discussions on what Tom just talked about? The absolute prohibitions. Go ahead.
That seems entirely reasonable. I agree with Tom.
Okay. So we're left with D as the outstanding controversial piece here. Okay, let's hear from Rabbi Kahana, then we're going to hear from
I'm
Paul.
just going to say, but before we move on, I'd like to hear the disagreement.
So the reason that it was in there, and if you look at page 38, the very bottom, and then to page 39, you see underlined what it talks about the carotid hold as being, that it is categorically defined as deadly force and required deadly force justification. So if you're going to do that, you have to categorically be able to say it's deadly force. Above, at least in the ones that I had, Mr. Steenson talked about being extremely dangerous to authorize a type of force, especially deadly force, which they've received no training. And what I try to think about is, what's more dangerous than deadly force? And now if that's the only option the officer has to stop somebody maybe from hurting somebody else in a crowded area and they don't want to shoot them, I guess I can't use a carotid hold to save that community member's life. Trying to take an option away from an officer when, again, it's very clearly spelled out here that it is categorically defined as deadly force, to take an option away from that might save a community member or another officer's life, I think is irresponsible.
I have a question. Paul, were you addressing H or D?
From what I have is H.
Okay, I thought we had moved past that, but no.
Past
Excuse
H?
me. We went back. Not HG.
Oh. So I was talking about H, I think, which is what we were on.
It just seems to me, I hear a lot of the conversation from the advisors here, and I trust you all to know when you're in an intractable conflict situation. So for me, I think of a conflict, when you're involved in a deadly force conflict, the time span between something, a decision about to use your fist against somebody's neck or having to shoot them is very close. I think, for me anyway, when I interpret D, I think of it as an officer is talking to somebody from a traffic stop, and the distance between the conflict from using just verbal warning to now you're using a baton is a vast, vast spectrum. So that's the way I'm interpreting this. So I guess I'd like to hear more about the distance in decisions when you're in these conflicts where you might be hurt, right? Does that make sense?
Do you want me to answer that, Mrs.
Shortly,
Sabat?
briefly.
Great question, and the time distance can be a micro of a second.
Right.
It really, you just don't know. It could be the door opens and now you're immediately in a physical confrontation. I think that we just saw where the door opens up and the officer's getting punched, or an officer's getting shot, or it could be instantaneous.
Right, so the totality of the circumstances in that situation would then, of course, you would use anything that you would need to in order to go home at night, right? Is that a reasonable assumption and
Well,
understanding on my part, or?
Depends on the level of
You
threat.
just what you just told me. You open the door and a person's,
Starts to assault you.
right, okay. There's that time span in the conflict where you must, in my view, right? If any of you were my partner or my wife or my husband or whatever, I would want you to get home.
Unfortunately, this recommendations in those two sections put a prohibition on those unless deadly force is required, and not all of those situations that are instantaneous like that, deadly force would be justified. They wouldn't be in a lot of those, in a majority of them.
I see the except when, and it's just like, you're covered.
That's the totality.
Totality, it's covered, but not with except.
Okay.
Somebody needs to do more work.
What I would like to entertain at this point is some look at this in a way that lets us move forward. Now, is that articulating? I think you were about to try to say what you think D should say. Paul has said what he thinks should happen with H. Can we look at D first and say what you would like to remove from D?
I would end it at, I believe friendly amendment is, I would include intentional strikes to the head, neck, throat, heart, kidney, groin, and spine with any authorized impact weapon, such as a baton, period.
Can be deadly force.
Oh, such as a baton, comma, can be deadly force, correct. Yeah, thanks.
And is that leaving in, therefore, such intentional strikes are prohibited except under the facts and circumstances deadly force is authorized?
Sure.
Okay. So that means, yes.
Motion to strike or with an officer's feet, knees, fists, and elbows?
Yes. That's what I'm reading. That's what I'm about to, yeah. Is that correct?
Correct.
Sure, okay. So the motion here is to strike the section that reads, or with an officer's feet, knees, fists, and elbows can be deadly force. That phrase.
No, leaving in can be deadly
Well,
force.
it's repeated in the last sentence. I think it's clear if you read the last sentence. Let me read it as it would be without that phrase. Okay? Intentional strikes to the head, neck, throat, heart, kidney, groin, and spine with any authorized impact weapon, such as a baton,
Can be deadly force.
Can be deadly force.
Period.
is prohibited. No.
No.
What?
Yeah, well, okay, I see what it, yeah, okay. Are prohibited. Therefore, such intentional strikes are prohibited except under the facts and circumstances of deadly force is authorized. So we would need to say are deadly force.
Can be deadly force.
Can be deadly force, yeah.
And just grammatically, it should say under the facts and circumstances where deadly force is authorized. Just to
Okay. Do I have a second for that?
second.
All right. So we're going to vote on this part first.
Just so it's clear, it's an unfriendly amendment from the perspective of the
subcommittee.
So it's clear.
Okay. So that is going to require a vote, and we're going to start with the list. We're going to call names. Rabbi Kahana,
Aye.
Bud Pulis,
Wait a second. Can we get the phrasing of it again?
Yeah.
you want to read it as,
Be nice to type it out the way it's actually proposed.
The vote right now is on a motion to strike, quote, or with an officer's feet,
knees, fists, and elbows, unquote, from Section D.
So that is the motion, to take it out of the proposal, made by Sharon, seconded by Rabbi Kahana.
Do you want to include the grammatic change, or does it matter?
We'll get the grammatic change, right?
Okay.
Yeah. Right. So, now I'm going to call the roll. And I think I said Rabbi Kahana, he said yes.
Yes.
Bud Pulis?
Yes.
Catherine?
I'll look for it.
Okay. Jimmy?
Aye.
Ime?
Abstain.
Sharon?
Aye.
Riviera? V?
Nay.
Silver?
No.
Steenson?
Nay.
Philip? Wolf?
No.
Okay, what's my,
4-4 with one abstention. And I let Catherine know that if her vote is a tiebreaker, we'll give her 3 minutes to make sure we're accounting for any lag.
Well, it's not a tiebreaker, I don't think, is it? Needs to be a quorum.
Yep.
yeah. Well, we have a quorum. What are you asking? You do?
The question would be, is amending a recommendation a major action?
I think it's
requiring
I don't think it's I don't, you consider it major, huh? Are you considering it a major
Yes.
change? Okay, so then, okay, it won't pass. So it will not pass. Okay.
We had decided before that that's a major action. and we-
Well, I'm
Yeah.
in
Unless you
agreement
want
that
to
it
vote
is.
on it.
Okay.
That it is. Yeah.
It's like officer safety. Seems pretty serious to me.
It certainly was controversial. So I have a hand down here. Philip?
Yes, I just want to clarify something. We are voting on the amendment, but since it has not passed, then the proposal still
It is
stands
as
and
it was.
can be
Yes,
voted on
yes.
as originally stated.
We had,
Okay. Okay. I move to vote on the recommendation.
well, I want to ask if there's any, there was some discussion on the use of the neck holds being an absolute prohibition. Is there any place that anybody wants to go with that? Yeah.
I just want to say that if it isn't taught, it shouldn't be used.
So you're saying you don't want to go anywhere. Okay, so here we have the specific prohibitions on the use of force. And there are elements ranging from A to I. And so I need a motion on whether to accept this. And a second?
Yes, I do.
I'm sorry. This is a, I'm sorry, I just got lost.
Motion to accept the recommendation.
The entire.
The entire thing,
The amendment.
the recommendation.
Seconded.
So, Philip and V. All right, so we'll go through again. To accept the recommendation as discussed. Kahana,
Nay.
Pulis,
Aye.
Johnson,
Aye.
Carolee,
Aye.
Marion, Myron, sorry,
Nay.
Revere,
Aye.
Silver,
Aye.
Steenson,
Aye.
Wolf.
Aye.
What do we got?
We have 7.
Seven.
We need
Without
Catherine.
Catherine.
We need to Catherine to weigh in.
Almost feels like chess.
Okay, so we have, do we have a weigh-in from any part, or? Yeah, but you need to find her name in there. Okay. We're waiting for Catherine. While we're doing that, I just want to point out that there's no way we're going to get through this whole list of things. So I'm going to try to put some time limits on the discussion. I try to leave it open because I think people really want to be heard. But there's a point at which, if we're going to get things going, we will need to, along with the public input, we will need to shorten the discussion time. And now, since Amy has let's take a look at the next one. Let's just start looking at that at this point in time, even though we don't have the final count on the vote. It's entitled Antecedents to the Use of Force. Before any use of force, an officer must, if time, safety, and the facts and circumstances permit, provide a verbal warning of the type of force to be used. If such a verbal warning is issued, the officer must provide the subject with time to comply. Yes. Okay. So we're passing it. On both those? Or on the first one? Did she vote on the first one?
No.
Can I just explain this one, the one we're getting to?
Yeah, I want to make sure that this is showing up. I was looking for the little green thing to go on, so I could say, yes, all right. It is passed. That recommendation is passed. Okay.
And the voting on the first one for...
No, we're just voting, we're listening to this now.
Okay. So now we're looking at antecedents to the use of force. And I just read you the synopsis. Officers, there's a little bit more. Officers should make specific attempts to determine whether the subject understands the verbal warnings that have been given, taking into account factors such as language, hearing, and cognitive ability. Officers should attempt to utilize hand signals where there's a language barrier or the subject is deaf or hard of hearing prior to using force. In such instances, officers should identify themselves as police officers. Also, if it is not already known by the subject to be detained, arrested, or searched, officers should, if reasonable, make clear their intent to detain, arrest, or search the subject. Now, Tom?
We can take a deep breath on this one. I think it's unopposed by anyone. It's clearly best practices throughout the country. Some of this is in the current policy. This is clear and more expansive.
We did have somebody sign up for public comment on this one. I think. No, this is the wrong one. I have somewhere lost a page. Yes, this was antecedents to use of force, Mr. Davis.
So basically, I've heard a lot of stuff about how the police need to protect themselves. Last time I checked, the community were the ones that the police are supposed to be protecting, and I think that maybe they need to actually be trained better to not have to use their guns. And, you know, she was saying that she's a 5'4" officer and she has little options. Well, I think that maybe you should be trained in martial arts or other various training moves. There's plenty of ways to de-escalate things and handle
Mr.
things
Davis,
without killing
Mr.
people.
Davis, we're looking at the next one now, the antecedents to the use of force. Can you comment on that?
I just wanted to comment that I was kind of,
If I may, Charles Johnson, and obviously there's some extensive documentation here, but I think when we have this phraseology of antecedents to the use of force and the warnings, just like anybody up there to review and see if we're talking about the level of risk that the suspect presents, excuse me. So, in addition to wanting to warn a suspect, we also want to consider, are we applying force to somebody who has just gotten a pack of Skittles and Arizona tea or some cigarettes? Or are we talking about a person who has been reported as a murderer? So if anybody among the COAB could respond to how they feel that issue is also incorporated into antecedents to the use of force. Thank you.
So you're asking that they evaluate risk as a part of the determination?
Not only risk, but the severity, well, I guess risk to the public. In other words, a shoplifter who's not reported as armed, or somebody fleeing from a traffic stop, a Kendra James is, don't give me that crap about her car as a deadly weapon, is not a risk as a person who's been reported to have just done a drive-by shooting. Thank you.
Thank you.
Thanks, Charles.
Anyone else? Okay. Tom, you want to talk about this one? You just said it was,
Well,
there was no controversy in
the
that.
language in there, Charles, that we have where an officer must, if time, safety, and the facts and circumstances permit, provide the verbal warning. That was the language we put in there to allow for consideration of a variety of factors, including risk. So I think it's covered.
Thank you, Tom. Rochelle?
I'd like to go ahead and move that we vote on recommendation 102215-6.
Okay, and Philip seconded, and Jimmy, did you want to say something? Okay, I think we have one, all right. Any more, are you ready for the question? Okay. Then this is a vote on the recommendation regarding the antecedents to the use of force that has been briefly discussed and found no controversy within the subcommittee. I'm asking for your vote. Rabbi Kahana?
Aye.
Bud Pulis?
Aye.
Catherine Gardner? And I guess we'll hear from her on the phone. Jimmy Johnson?
Aye.
Ime Curley?
Aye.
Sharon Marin? Myron? Okay, I look at the spelling and I keep messing up. Myron?
Y-R-O-N.
This has never happened.
Okay.
Aye.
Okay. V. Revere?
Aye, yes. Absolutamente.
Rochelle
Yes.
Silver? Tom Steenson?
Aye.
Philip Wolf? Okay, unanimously passed. Is it time for a break yet?
Are you tired? Come on now.
How about a 10-minute break?
Yes.
Okay?
Aye.
10-minute break.
Oh, goodness, that was me. I'm so sorry.
If I have to leave for.
Okay.
Me too.
Welcome back. We're looking at recommendation 102215-7, other requirements. The synopsis is, each officer present at an encounter where the use of force is possible or underway has the responsibility of making individual determination regarding the use of force. Force should not be used on a subject by an officer solely because another officer is using force. As example, dogpiling is usually unreasonable and should be avoided unless determined objectively reasonable, necessary, and proportionate to the threat, if any, posed by the subject, and intentional strikes with impact weapons such as batons or an officer's hands, elbows, knees, and feet, just because another officer is making such intentional strikes, is prohibited. B, an officer has a duty to intercede to prevent the unreasonable use of force by another officer if the officer has reason to know that unreasonable force is being used. C, if the use of force is being discussed among officers, an officer has a duty to speak out against the use of force if the officer believes it is not objectively reasonable, necessary, or proportionate to the threat, if any, posed by the person who force may be used against. Tom, do you want to say something about this?
Again, these provisions are best practices. In fact, in some form or another, 2/3 of these already appear in the Bureau's policy. They're not really in controversy. The advisors have pointed out that they do exist in some form or another. We simply compiled them in a format that we thought was a little clearer. It also incorporates the language about objectively reasonable, necessary, proportionate to the threat from the previous recommendation that was passed regarding determining force in general as to whether or not it's reasonable. So I think it's a recommendation that is not in controversy or really being disputed.
Okay. Any public comment on this one? Okay.
Good evening, thank you. I'm Charles Johnson. And I think with the people we have from the training staff here of PPB, I think that we want to promote the conversation, not just that officers should be prohibited from using force in general. When we have that language, it implies that what we've seen too often is that some officers think that their job is to show up and apply force. And I know that the current leadership of the police department is trying to engineer a culture change with the Portland Police Association and the officers so that they know that their job is to show up and apply the skills they have to de-escalate situations. While we have to have some language of prohibiting force, I think that we need to frame it in the general conversation of service that high violence crimes are relatively rare, people in distress is more common, and the context of how often are police officers service providers rather than force suppliers. So yes, we want the language that is there in case of litigation that says officers are prohibited from applying force unless there's strong evidence of its urgent and immediate necessity. But I think that we also want to, in our discussion about this, have the idea that we're crafting a police department that's not just a force. It's a public service. Thank you.
Thank you. Anybody else? All right, discussion on the COAB? Philip?
I move to vote on this recommendation.
I'd like to second.
Okay. Any discussion on the content? And any thoughts on the testimony we just heard, the public input we just heard as a part of this? Or how would you like to handle it?
I agree with his comment.
Tom, do you have a feeling about how you'd like to have that handled, given the proposal?
Charles, well, I'm not sure how this particular recommendation should be amended. I can tell you that we have approved previous recommendations that have very strong language about de-escalation, disengagement, the mission being the value of life. Force should be used only at the minimal level. There's a standalone de-escalation policy. It's far superior from the current Bureau policy in that regard. That has, I think, 2 words referencing de-escalation. So I think there's a major emphasis in some of the previous recommendations. I don't disagree with your comment. I think that it's been handled relatively well.
Thank you. I don't have any specific language recommendations. That was Carrie's point. I just want to make sure that.
It does sound like that you're introducing something more conceptual than the mechanics, something as a philosophy or a value.
I'd agree with the chair, Madam Chair. What do you prefer, chair or Madam Chair?
Just whatever. So maybe we should just keep that in our minds to help us inform the work that the COAB is doing.
Well, I think that in the first 4 recommendations that were passed in December, that philosophy is there about the value of human life and de-escalation, et cetera, et cetera. So that is something that the Data Systems Use of Force Compliance Subcommittee took very seriously.
Thank you, Rochelle. Any more discussion on this particular recommendation? Do I have a motion for the acceptance? Philip? And? Okay. Then we'll call the roll on this, the other requirements. Kahana?
Aye.
Pulis?
Aye.
Gardner? Johnson?
Aye.
Curley?
Aye.
Myron?
Aye. That was hilarious.
Riviere?
Aye.
Silver?
Aye.
Steenson?
Aye.
Wolf?
Yep.
Pass.
Oh, goodness.
All right, we're going to go to 8 now. It says miscellaneous as the heading.
That means that's the most dangerous one, right?
No.
And I'm going to, okay. Implementing the Data Systems Use of Force Compliance Subcommittee's 6 other recommendations will greatly improve revised Directive 1010 use of force. This final recommendation, while not having the weight of the previous ones, is nonetheless important. The revised directive and all other directives on force should use the words fact and circumstances rather than just circumstances when listing the factors to be considered in determining the objective reasonableness of force. B, use the word weapons for actual weapons such as firearms, beanbags, shotguns, electronic control weapons, tasers, batons, and aerosol restraints, pepper spray. Use the word tools for non-weaponry such as handcuffs and de-escalation techniques. C, make specific changes to the procedure section in the current directive. I, section 3.1, change the word important to critical. Double I, section 9.3, each member who uses physical force will Add word separately, I don't know what that means. Oh, add the word separately. Complete a force's data collection report. So that is each member who uses physical force will do a separate force data collection report. Section 11.1.2, supervisors shall address deficiencies in reports promptly. This should be clarified to explain what is meant by a deficiency. Supervisors should not tell officers what words to use or how to say something to make the report comply with policy or training. Discussion. Or Tom?
I don't have anything really to add.
Any discussion on this? Rabbi Kahana and then Bud?
Thank you. I'm curious about C3. It doesn't seem like there's specific language that's being recommended, only an intention. Or can you clarify on that, please?
We were just concerned, the last sentence about supervisors helping officers, suggesting to officers what language in a report might help them comply with the policy or training, because of the risk that's going to skew the officer's version of what may really be true.
Mm-hmm.
So it's a general recommendation. We didn't have specific language.
Does that, I understand and agree with the intention. Does it work to simply insert this as a concept and not to give specific language?
Well, this is not the only recommendation that is conceptual. I mean, we've been pretty specific on things, but I suspect that the DOJ or the Bureau may see some things as conceptual and then take them a step further even. So I think it's fine. I don't have any problem with it, but.
Thank you.
Bud?
So this question is both to Tom and to Paul. On section A, we say use the words facts and circumstances rather than just circumstances. And this relates to the definition of what is objectively reasonable. Do we get to make that definition in our policy? Will that hold water in court? Or does the court have its own definitions of what's objectively reasonable that would make this not hold up?
Well, let me just address that as a general matter. The subcommittee did not feel constrained by what the law may or may not allow a police officer to do.
Excuse me, just a minute, Tom. Would you guys step outside and hold your conversation, please? Thanks. Go ahead, Tom.
What may or may not allow police officers to do. We looked at what we felt were best practices and what would be best for the city of Portland. And just like the current policy says, in some respects, it's more limiting or more restrictive than the Constitution. That's the same approach the subcommittee has taken. That we have tried to do what we think is right for the city of Portland, given the history of why the DOJ is here.
Just a minute. Paul was asked that question also.
When we look at the Constitution, what the United States Supreme Court says, I think we have to be very careful on what we limit. There are certain, when the U.S. Supreme Court says that you will do this, that is what we will do. I think there was a problem with that down in the southern part of the United States on a recent United States ruling. I think we need to be very careful with that.
A problem with this language?
With not following what their rulings are and their direction is.
Okay, hold on 1 minute, Rochelle. The question I hear, is your question answered, Bud?
Yeah, I think I got the information I needed. Thank you.
Okay.
I don't know what part of the South you're referring to, Paul, but these words, facts and circumstances, are in the policy of New Orleans. And that policy was approved by the Department of Justice. So in part, we took that language from that policy.
And that would be the Deep South.
Further discussion?
It actually is.
Rabbi Kahana.
I'd just like to, I guess this is a question to Paul. I'd like to understand the difference in between facts and circumstances and totality of circumstances.
So totality looks at everything. The Supreme Court has even talked about the hunch of the officer, that has to be taken into consideration in certain things based on their training and experiences. So circumstances, I guess, would cover that. I think it's semantics. I think the totality of the circumstances stays consistent with what the United States Supreme Court says.
I have a quick question.
That's my best answer, I guess, to it.
Thank you.
B.
I would feel more comfortable if we had, thanks, Michelle. If we had, or asked the person from the DOJ to maybe comment on that, if that's possible? Facts, circumstances, totalitarian of the circumstances.
Sorry, that was good.
Hi, I'm not prepared to discuss
I'm sorry.
this issue, but I don't mind opining anyway. As I understand it, the totality of the circumstances would consider facts, facts and circumstances. I don't think the totality of the circumstances would consider false realities.
So they're not mutually exclusive?
I don't see them as mutually exclusive. I don't know if a court has opined on that. I would understand totality of the circumstances to mean facts and circumstances.
Thank you so much. Good to see
The
you.
reason we used facts and circumstances is it's a direct quote from the Supreme Court, as opposed to circumstances. And that's why we wanted to add it.
Bud.
I'd just like to suggest, and please tell me if I'm wrong, the difference I hear has to do with perceptions, where we often talk about an officer's perception that his or her life was in danger. And when we say facts and circumstances, it seems like we're driving out that question of perception, which is currently fitting under the category of totality of circumstances. I'd love to hear whether I'm getting this right, but that's just what I'm hearing.
Ontological argument?
Anybody want to take that on? Okay. Sure.
My own personal feeling, just totality of circumstances and facts and circumstances are pretty similar. I don't see significant difference.
Okay. If there's no more discussion,
You haven't got public comment on this.
oh, public comment, yes.
Hi, Dan Hamilton again with Portland Cop Watch. And yeah, I was going to point out, it is actually in your packet, the direct quote from the Supreme Court that says facts and circumstances. But beyond that, the concept that our policies can be more narrow than what the courts say is so that officers can be held accountable in our administrative system, even if they're not going to end up being held accountable in a court of law. So worrying about the court is not particularly relevant because the city can make a reasonable policy, then hold the officer accountable if they violate that policy. So there are two different issues, the court and the administrative investigation. And I just want to thank the committee for including the part about using the word weapons, because that's one of the things that bugs us a lot at Cop Watch. Thanks.
Okay, thank you, Dan. Anyone else?
Yes, please. Charles Johnson. One thing that I think is problematic with public relations and a particular phrase that has become popular in police lingo is aerosol restraints. I'm glad to see them referred to as weapons, but at another time, maybe in a subcommittee, we could get some honest conversation about the effect of pepper spray on people and whether it's in any way interpretable as a restraint or a force, a provocative. Of course, all weapons are provocative force, but particularly pepper spray, I think, may be a solution that officers would want to engage with the public about its effectiveness. Of course, it's notorious because a jury has told us it's okay to squirt it down the throat of young women in Portland. But aerosol restraints, I think public intercourse with the police department would be improved if we didn't have such facetious language for that particular term. And then there was a general sentiment of vagueness around C3, which referred to section 11.1.2 and supervisors addressing deficiencies in reports. Personally, I haven't yet gone through the IPR and CRC process, but that's another issue of where this panel has its specific settlement agreements plus community confidence issues, in that a number of public members that I've engaged with and people on the IPR are sometimes concerned with scarcity or inaccuracy in reports. And this isn't meant, and this is just meant to encourage the training staff at the police department to allot a serious amount of time to creating good public records in police reports, not CYA documents. So I hope that individual COAB members or the COAB officially will engage around the issue of what the community thinks is an effective police report. Thank you.
Thank you, Charlie. Laura?
Thank you. I recently was at a trial where Paul Myers, you had, there was words that were used in the trial over and over, and that those two words were a hunch and a ruse, and you just mentioned a hunch. And I just want you to maybe, I'm confused as to how a hunch and a ruse, you said at the trial, and you testified as an expert, that the hunch or that that the Fifth Amendment had a loophole or there's a conflict, and within that conflict gave the officers the right to violate Lisa Haynes' rights. I see it as a violation when you use that loophole. I know that the police officers were exonerated over and over and over again, but I want you to explain how is it that on a hunch and a ruse, those directives, because all the police officers use those terms, including you. So that's a directive that's being placed by the police department. It may not be written on piece of paper, but every single officer that testified used those two words, a hunch and a ruse. And so if you can please explain how it doesn't violate the Ninth Amendment, because the Ninth Amendment, the way I understand it, you can't construe a crime to violate somebody's civil rights. And Lisa Haynes, that was not a dispute. Lisa Haynes exercised her Fifth Amendment and her Fourth Amendment right. And you testified that, that the Fifth Amendment had a loophole using the words a hunch and a ruse and hypotheticals. Thank you.
Okay. Paul, would you start out by defining the words?
So a lot of things there that aren't very accurate to what I said. What I did talk about was a hunch, and what I talked about there was, I think it's U.S. versus Arvizu. It's a U.S. Supreme Court case where they, if I'm not familiar with it, they reversed the Ninth Circuit Court of Appeals. And what they talk about is that for a stop, that the totality of the circumstances have to be looked at to determine if the stop is reasonable. And one of those things that has to be looked at is what they would call a hunch, and that is articulable things that the officer saw, and then it has to be articulated about why they believed what they believed. So it's not just a simple statement that, oh, I thought they were running drugs because of this. No, why exactly is it that you believe that? And then again, that has to be articulated by the officer. And then it is a jury's job to determine the reasonableness of that, as we saw in Mrs. Haynes' stop court trial.
So as I'm hearing this, it sounds like a hunch is a part of the totality of circumstances as you're looking?
Yes,
One
it would
aspect.
be.
But it requires description.
Well, they all do. They all do, yes. So the officer would have to say based on their training or experiences, and actually the court even says that what the officer perceives based on their training and experiences and what is going on, that might not, I don't have the exact language, but the gist of it is that might mean nothing to the average community member. But because of the officer's training and experiences, it does. That is only one factor, and again, it has to be articulated. That is only one factor amongst all the ones that they have to describe under the totality of the factors.
So would that be considered a circumstance? Would that fall in that category?
I'm not a judge or jury. Yeah, I would think so. That is part of that, yeah.
Okay.
So,
More questions, more discussion?
We didn't get an answer to
Okay.
what is this ruse
I've
term?
never used that word.
Oh,
That word was used by all the police officers in the trial.
Except I did not use it though.
But you did use hunch and a ruse. You did use those,
What?
yeah. I mean,
Well-
Not a-
and, I'm sorry.
Okay, okay.
A hypothetical and a
we're not
hunch.
talking.
The hunch he just talked about. So is there something you want to say about hypothetical at this point?
Can I keep this to
Yeah.
to this conversation?
All right.
I mean, I think this is helpful. And I'm sorry, well, I wasn't
Yeah,
recognized.
that's okay.
I want to. We're talking about the choice between two different phrases: facts and circumstances, or totality of circumstances. I think that's.
No, that's a part of this discussion as I see it, and I'm simply trying to get at the nuances under totality of circumstances and facts and circumstances.
Yes, correct. Again, for our purposes, the recommendation here is to use the phrase facts and circumstances. The counter that was in the notes is to replace that phrase with totality of circumstances. We're not voting on that yet, but before making a recommendation for a change, I want to understand the difference between those two phrases. So if I can, Officer Meyer, is the concept of hunch that you just described, which is very interesting and I think very helpful, is that excluded under facts and circumstances?
No.
My opinion is no.
The language as suggested wouldn't exclude the possibility of a hunch.
That's my opinion, yes.
Yeah, that's why I asked whether it would be under the category circumstances.
Thank you.
And V, you had a question, or you had your hand?
Yeah, I guess, Philip?
Yeah, I just wanted to point out the difference between so the fact versus circumstantive. Okay, so if we were just talking about circumstances without having the wording fact, that would be different between facts and circumstances. So that's what I wanted to point out. There are differences, and when you put facts and circumstances together, it does include more. When you're talking about a hunch, it's not necessarily fact. It's assumptions based on experiences, previous training, and different things. It's not necessarily a fact. It can be more of an opinion. It could be an incorrect hunch, actually. And others who are using the word hunch, it could mean that it may not be a wrong thing because the perspective from the officer, but it could be a wrong thing. It could be incorrectly misinterpreted by someone who is not an officer. So, but I would like to point out that a hunch is not a fact. And with that said, I'd like to close discussion and open for vote.
Is that a proposal?
Second.
Yeah.
Okay. So we're looking at miscellaneous now, right? And this is, discussion has concluded. We have a motion and a second. You have one more piece? Yeah, we have a second. I do believe. Yeah, right. So we're going to call the roll on the vote now. Kahana?
Aye.
Bulis?
Aye.
Gardner?
Aye.
Johnson?
Aye.
Hurley?
Aye.
Myron?
Aye.
Revere?
Aye.
Silver?
Aye.
Steenson?
Aye.
Wolf?
Aye.
Passes. I'm looking at 111-215-1. Or did I miss anything? All directives related to use of force should be revised to be clear, comprehensive, and consistent with the COAB's anticipated recommendations regarding Directive 1010, use of force, and previous recommendation regarding Directive 1010, post-deadly force procedures. See packet for further explanations. All directives related to use of force, such as directives 315.3, is this? Yeah. 315.30, satisfactory performance, 630.15, foot pursuits, 940, after action reports, 1020, firearms, 1030, baton use, 1040, aerosol restraints, 1050, less lethal weapons and munitions, 1051, electronic control weapon system, and 1090, special weapons use, all attached, should be revised to be clear, comprehensive, and consistent with COAB anticipated recommendations regarding Directive 1010, use of force, and previous recommendations regarding Directives 1010, post-deadly use of force. The revisions of such directives should include: merge the policy and procedure sections by deleting sections on procedure. Provide clear and comprehensive definitions for words and acronyms such as SERT, RU, EMS, DBD, MCDC, LOS, and others. Delete references to rescinded directives such as former Directive 1010, deadly physical force, and 1020, physical force. Add correct references to current activities. Tom?
It's kind of a housekeeping recommendation. The current policies are kind of a hodgepodge, and they're confusing, and we're trying to suggest that that be changed.
Discussion on the recommendation. Any public input?
Thank you again, Charles Johnson. I think this overall is illustrative of the difficult work of growing public confidence in the police when we have such an array of issue numbers. I think that if public sentiment is growing suspicion towards the police, I hope that both ourselves and the police will particularly consider language such as electronic control weapon system. No. It's an incapacitator. It doesn't really provide control, except, of course, it hopefully makes it easier for the officer to increase their level of control because the person's spasming on the ground or inert. But, when the police, as part of their supply industry, get a nice phrase like electronic control weapon system for taser, and the idea that, there's some kind of control there. I mean, anti-police people, that's triggering language for them if you're going to subject them to a control weapon system or a control system. So police community relations, I think, would be improved if we just call it an electronic incapacitation tool or something like that. I realize it's not the Portland Police's delight to bring these phrases. They mostly get them, they're mostly sold to the police, actually. But I think that we're trying to go above the floor of Supreme Court or Ninth Circuit decisions and have the best, most humane possible policing and language around that policing. Thank you.
Thanks, Charles. Any thoughts on the, oh, Dan? Dan, are you coming to the mic? Oh, okay. Philip? Okay, Nancy.
Concerns I have right now is the introduction of electromagnetic fields in police activities, and I've only heard hints of this, but it's been introduced in war games in the forests of the state of Washington, and the Navy is using them. And this actually has an effect of making mush out of whales' brains in the oceans. This is all true and it's happening. So have we had anything of that nature introduced into any cities in the United States? Because we're now so into using electronic technologies for somehow behavioral or controlling factors. And I'd just be curious to know if anybody's had discussions with you about that, police hearing of anything like that. I would really like to know. The fact that we do it to animals is certainly not a healthy society.
Tom, you got anything to say on that?
The one thing I would say is there's a directive called 1090 Special Weapons. And what we learned in looking at the directive is that apparently the Bureau sort of experiments with weapons, and they're not necessarily disclosed or made known to the public. And when we get to the recommendation, we're asking that there be a comprehensive, up-to-date list if there are other weapons than the main ones that we'll be talking about that are being used on an experimental basis or otherwise. And I don't know anything about that specific one, but that directive that I'm talking about, or our recommendation, would sort of address the issue.
Okay, B?
So that would make me wonder about public health concerns too, and maybe evaluation. I look forward to getting back to the committee. Thank you, Nancy. That's freaky.
More discussion?
I had something. I just wanted to mention that the recommendation is pretty much basically in support of the reason that we are here. It's to help develop more trust between the police and the community members. So with that, I mean, that seems pretty obvious, but I don't see why there's any reason whether anyone would be against this recommendation. So with that, I would move to a vote to pass this recommendation.
Second.
All right.
Who was the second?
Excuse me?
Sharon. Myron.
Myron.
It was Myron. It was the Myron.
Yeah. Okay.
Can I,
Yes,
just
Rabbi
just a
Kahana.
comment along the way. I don't see anything offensive, but much of this, as you say, is housekeeping, and it's a little bit hard for me to track without actually knowing what these issues, what the sections are that are being deleted, and so it's
They're all in the packet.
So
I find myself at a little bit of a crossroads. There's nothing I object to, but I don't understand it exactly.
The deletion refers to policy and procedure. The way the current directives are set up, there's a policy section and a procedure section. And they don't make a lot of sense. At least we didn't think they made a lot of sense to have separate sections because it's all policy. And so that's why we're suggesting that it be separated and deleted.
Oh, it's deleting the word.
Yes.
But merging the two into one unit.
Yeah, because it's all policy.
Okay, I didn't understand.
And it's
that.
confusing what procedure even means.
That's helpful, thank you.
It's been moved and seconded that this recommendation be accepted by the COAB. I'm going to call the roll. Kahana?
Aye.
Pulis?
Aye.
Gardner? Johnson?
Aye.
Curley?
Aye.
Myron?
Aye.
Revere?
Aye.
Silver?
Aye.
Steenson?
Aye.
Wolf?
Well, I don't know. Maybe. Well, duh, yes.
Thank you, George Burns.
Okay, moving right along. 111215-2, revised Directive 1030, baton use to clarify when the use of police batons is authorized. Okay? That is the title of the recommendation, and I'll try to get to the text. Well, oh boy. The full text of the recommendation is on page 57, or is that where it starts? Yes, page 57. Directive 1030 should be revised to clarify when the use of police baton is authorized and include at least the following. The collapsing, telescoping police baton is an impact weapon. The rewrite of Directive 1020, baton use, should clearly state when the use of the Bureau-issued straight collapsing telescoping police baton is authorized. Before resorting to the use of a police baton, officers shall use all reasonable de-escalation techniques and tools which are available to them to avoid the use of such force. Officers shall only use the police baton when objectively reasonable, necessary, and proportionate to the threat or resistance of the subject as defined more fully in Directive 1010, and only to overcome aggressive resistance or aggravated resistance. In addition, each use of a police baton must be objectively reasonable, necessary, and proportionate to the threat or resistance encountered as required by Directive 1010. Police batons are not authorized to overcome only passive resistance or active resistance by an individual. Unless it would present a danger to the officer or others, officers shall issue a verbal warning or attempt to utilize hand signals where there is a language barrier or the subject is hearing impaired prior to each strike with a police baton or other impact weapon. Officers shall give the subject sufficient time to comply with the warning before striking the subject. A warning shall be given prior to each strike. Preferred target areas include arms, legs, and torso. Officers are prohibited from using the police baton under these facts and circumstances. A, officers are prohibited from using police baton on subjects who are restrained and under control or complying with police direction. B, intentional strikes to the head, neck, throat, heart, kidneys, groin, and spine with the police baton or any authorized impact weapon can be deadly force. Therefore, such intentional strikes are prohibited except when under the facts and circumstances deadly force is authorized. C, officers are prohibited from using a police baton as a form of punishment or for retaliation. D, officers are prohibited from using a police baton to prod or jab individuals, to awaken unconscious or intoxicated individuals, or to prevent the destruction of evidence. Alternate D, officers are prohibited from using a police baton as an instrument of force on unconscious or intoxicated individuals or to prevent the destruction of evidence. Officers shall consider risks to the subject and third parties when determining whether to use the police baton. Officers may only use the police baton on suspects who are visibly pregnant, elderly, apparently pre-adolescent, or visibly frail when there is an emergency or an immediate threat to officers or third parties. Use of a police baton in the following circumstances is only authorized in situations where there is a risk of death or serious physical injury to the officer or third parties. When the suspect is in the elevated position where a fall is likely to cause substantial injury or death. When the suspect is in a location where the suspect could drown. When the suspect is operating a motor vehicle or motorcycle and the engine is running or is on a bicycle or scooter in motion. When an individual is handcuffed or otherwise restrained. When an individual is fully contained in a police vehicle. Pretty extensive. Now, under D, Tom, could you talk a little bit about why you have the alternate there?
Well, there was a dispute, a disagreement in the subcommittee we couldn't resolve, so we presented it alternatively. The alternative language is broader than just the prodding or jabbing language. And so that was the dispute. I'm not sure there's a lot of difference. My proposal is we just vote on the recommendation as is and let the Bureau and the DOJ see the two alternatives.
Is that you proposing?
Well, that's how we drafted it, so I don't, unless somebody has a different proposal or motion.
Paul?
With all of the use of force weapon systems that we're talking about, I would say that we'd go consistent with what Seattle does. I think there's a move to do that within the police department where the directives relating to specific impact weapons or baton or taser would be more of an administrative thing and refer to the use as back to the use of force directive. As I'm looking at Seattle's right now, and as I'm looking at a few different impact weapons and batons, it's a very simple line. It says officers shall use impact weapons when objectively reasonable. See manual section. It refers to their use of force section. I look at Seattle's section on impact weapons and it is nowhere near the size of this and length of this. And so again, I think any one of these systems that are being used has to, if it's force, it has to come back to the use of force directive. So as the thing says it in here that at the DOJ settlement agreement it has best practices, my recommendation is that to keep things as simple as possible so that we're not making it more confusing for everybody. The use of it will be governed under the use of force policy, and the directive itself would be kind of an administrative directive on what it is, like Seattle's.
We spent a good time on this one as well as the other use of force related directives. We looked at Seattle specifics, we looked at New Orleans specifics. Some were consistent with each other, some had others. We took everything we thought would give clear direction and limit discretion in an attempt to limit the use of force. And we thought that that was helpful to officers. And that's why we provided this standalone directive. The Bureau already has a standalone directive on baton use that doesn't say much. And this one says a lot because we think it's important to say it.
I have a question, or more of a comment for Tom. On page 57, you can see the phrase, and there's one word I felt like was inappropriate culturally, because in my community we don't use the word hearing impaired, and hearing impaired is considered a pathological view of a let's say it's a doctor, a rich white man doctor who had created the term hearing impaired, which means it's the hearing is broken and it can be fixed. And so it's derogatory, it's not accepted in our community and the deaf culture in general. So what we use is deaf or hard of hearing in our culture. And so I just would like to amend the wording on that. Other than that, I agree with the recommendation. If there's no further discussion, I move to, or first just after changing that, if that's all right with you, Tom?
That's more than a friendly amendment, and I apologize, Philip, because you had raised the issue before, and I tried to catch it in the directives, and I missed this one, so I apologize.
No, it's fine. It's all right, and that's why I'm here. That's totally why I'm here.
Public comment.
Thank you, Charles Johnson, and I do lean towards this idea of rather than having a consolidated Seattle-style refer back to the Don't Hurt the People directive, where we talk about that we pass this with these many clarifications and informative points for the officers to ingest as they think about using a steel rod to smash a citizen in a special place so they'll be less capacity. I would also like to have anybody respond. When we, one of the sad things about American culture is we sort of picture officers with nightsticks, different than the collapsible, extensible baton. And then it almost seems like there's a nightstick on steroids that is part of the riot gear. So if one or more COA members could speak to whether those issues were addressed. The nightstick and the super nightstick club.
You mean that the big one? Is that what you're talking about? When they've got the...
I hate to think of what range of sizes they have, but that should probably be disclosed somewhere.
Michelle. You guys talking about that
One of the things, excuse me, that was mentioned at the beginning of the discussion of all these recommendations is that we are not writing the recommendations. The Bureau will write the recommendations in consultation with DOJ and maybe COCO. And whether this turns out to be a standalone directive or it's consolidated with other directives, I don't think is our issue. We just want to be sure that the ideas here are incorporated in policy.
Response to your specific question, I think those are, Paul may have the answer, I think those batons are only issued specifically on certain occasions. They're not carried routinely. We have not, our subcommittee has not addressed the use of those particular riot or whatever situation they use them in.
Are they called police sticks?
I don't know what they're called.
Paul, do you have any information?
They are used for the crowd control team, and they're a baton, straight stick baton.
Thank you, Paul.
Sure.
I move that we accept this recommendation.
Second.
Philip got it.
Oh, Philip did it. Oh, I'm sorry.
He's pretty quick. He's quick to the draw tonight.
Okay, this is the recommendation on baton use. To clarify when the use of police batons is authorized. We'll start with calling the roll. Rabbi Kahana.
Aye.
Bud Pulis.
Aye.
Catherine Gardner. Jimmy Johnson.
Aye.
Ime Curley.
Aye.
Sharon Myron.
Aye.
V. Riviere. Rochelle Silver. Tom Steenson.
Aye.
Philip Wolf.
Aye. Yes, yes, yes.
All right. We probably have time for one or two more, if there are.
Madam Chair. I apologize.
No.
I apologize. I have to leave early, so my
Thank
apologies.
you. Thank you for being here, and thank you for your input.
Thank you for your service.
Thank you for coming.
Okay, now we're looking at recommendation 111215-3, revised Directive 1040, aerosol restraints, to clarify when the use of aerosol restraints, pepper spray, is authorized. See packet for further explanation. Full text of recommendation is attached to the cover sheet, and it is page 61 through 63. Directive 1030 should be revised to clarify when the use of aerosol restraints or pepper spray is authorized and include at least the following. Aerosol restraints or pepper spray is a weapon. Pepper spray is an inflammatory agent that causes an intense burning sensation of the skin, eyes, and mucous membranes. A 1-second burst applied directly to the face, direct exposure, even with glasses, will usually result in the immediate closing of the eyes. The individual's eyes will likely close, tear, and swell as a result. When inhaled, secondary exposure, the respiratory tract will likely become inflamed and temporarily restrict breathing to short, shallow breaths. The individual may experience choking, gagging, gasping for breath, or in rare occasions, unconsciousness. The individual may experience nausea, lung pain, or temporarily impaired thought processes. The individual may become disoriented or lose his or her balance. The PPB shall seek guidance from the medical community on the dangers associated with the use of pepper spray. Before resorting to the use of pepper spray, officers shall use all reasonable de-escalation techniques and tools which are available to them to avoid the use of such force. Officers shall only use pepper spray when objectively reasonable, necessary, and proportionate to the threat or resistance of the subject, as defined more fully in Directive 1010, and only to overcome aggressive resistance or aggravated resistance. In addition, each use of pepper spray must be objectively reasonable, necessary, and proportionate to the threat or resistance encountered as required by Directive 1010. Unless it would present a danger to the officer or others, officers shall issue a verbal warning or attempt to utilize hand signals where there is a language barrier or the subject is deaf or hard of hearing prior to using pepper spray. Officers shall give the subject sufficient time to comply with the warning before applying pepper spray. A warning shall be given prior to each application of pepper spray. Officers must justify each application of pepper spray and should continually reassess whether additional applications of pepper spray are objectively reasonable, necessary, and proportionate to the threat or resistance of the subject as defined more fully in Directive 1010, and only to overcome aggressive or aggravated resistance. Officers shall direct pepper spray at the specific subjects who are engaged in aggressive or aggravated resistance as defined in Directive 1010 use of force. Officers shall not direct pepper spray to overcome only passive resistance or active resistance by an individual. Use of pepper spray in the following circumstances is only authorized in situation where there is a risk of death or serious physical injury to the officer or third parties. A, when the suspect is in an elevated position where a fall is likely to cause substantial injury or death. B, when the suspect is in a location where the suspect could drown. C, when the suspect is operating a motor vehicle or motorcycle and the engine is running or is on a bicycle or scooter in motion. D, when the individual is handcuffed or otherwise restrained. E, when an individual is fully contained in a police vehicle. Officers shall assist exposed subjects with decontamination and water flushing or use an other more appropriate counteragent to clean exposed area as soon as feasible, including at least the following. A, if the subject was exposed inside or in a confined space, officers will remove the subject as soon as possible from contaminated area and expose the individual to fresh air. B, officers shall request medical response or assistance for all subjects exposed to pepper spray. C, officers shall continue to monitor exposed subjects for changes in their condition while in police custody, and again request medical evaluation if the subject exposed to pepper complains. Officers shall be certified on the use of pepper spray. Officers shall receive annual pepper spray in-service training, including proficiency and policy changes, if any. In addition to these policy provisions, the subcommittee is concerned about several additional issues related to the use of pepper spray and recommends further study and research and additional policy changes as appropriate regarding the following. A, the potency or hotness of the pepper spray being used by the Portland Police Bureau is a concern. If it is possible to use a less potent pepper spray while still maintaining its effectiveness, then the least potent but still effective pepper spray should be used. B, the length of time pepper spray is applied is a concern. If it is possible to use pepper spray from a canister that regulates the maximum length of each application, for example, 1 second, that type of canister should be used. C, the distance from the subject that pepper spray is applied is a concern. The furthest distance away the pepper spray can be applied and still be effective should be the standard. Before we start discussion, I have a question that maybe you could help me with. The difference between aggressive or aggravated resistance, just
There's terms that are defined in the New Orleans plan.
Well, I just wanted a capsule, a little short sentence. Can you do that, Tom?
Well, so I don't get in trouble with anyone. The previous session we had where we approved recommendations on 1010 included a use of force continuum that relied upon specific definitions of passive resistance, active resistance, aggressive resistance, and aggravated resistance, increasing in terms of the threat that the particular person would be presenting. So aggressive resistance is a subject's attempt to attack or an actual attack of an officer, exhibiting aggressive behavior, for example, lunging toward the officer, striking the officer with hands, fists, kicks, or any instrument that may be perceived as a weapon, such as a knife or stick, are examples of aggressive resistance. Neither passive nor active resistance, including fleeing, pulling away, verbal statements, bracing, or tensing, constitute aggressive resistance. Aggravated resistance, when a subject's actions create an objectively reasonable perception on the part of the officer that the officer or another person is subject to imminent death or serious physical injury as a result of the circumstances and or nature of an attack. Aggravated resistance represents the least encountered but most serious threat to the safety of law enforcement personnel or another person. So the recommendation is very specific. The current Bureau policy is not specific at all as to the two levels of resistance that would be necessary in order to justify the use of pepper spray.
Okay, thank you. Right. V.
A couple of questions or
Go ahead.
clarification. So, Tom, I'm wondering, or maybe Michelle, will answer my question. So, the current directives about the pepper spray, when there's a, like a march or a rally or something like that, and PPB has to bring in other personnel, like say from, like the sheriffs are the ones in the green, right? I've seen them in the green anyway. Are they not bound, but do they follow the PPB's policy, or how's that work?
So crowd control is a different, excuse me, but for them to use it there, it starts to move towards where they have to have on-scene authorization from a supervisor that's there. That's somebody that's running that group or squad, or whatever word we want to call it, a group of officers. And usually where they're using it is when there's a threat of physical injury to the officers.
Okay, so then, does this policy, this is my question, does this policy here, the ones that PPB currently has, are the sheriffs bound by the PPBs? Is the county bound by the city's policy?
I don't know how that works. Not being on the crowd control team and not being part of that and the discussions that go on there, that would be somebody above my rank that would be able to answer that probably best. Sorry.
I thought you were a commander.
It'd be nice. Not quite.
That seems to me to be a critical issue, because from what I've seen, they're so often called in, and there are different displays of behavior than what I'm used to from the PPB. It would be nice to maybe somewhere work that into this this policy. I don't know, Tom, I don't know, or something else. And then the second point that I wanted to make is, if in this policy, if you all believe this covers the possibility of a child being sprayed. So, because that does happen. It did happen. And not from the PPB.
Is that a question for Tom?
The only thing I can say about the sort of the interjurisdictional or two different law enforcement agency issue is, as far as I understand, unless there's a specific joint agreement, a sheriff's deputy has a different policy than does a Portland Police Bureau officer.
The one thing that I can think about on this is that you're going to have an overall supervisor or command personnel who's going to oversee the entire operation, the entire crowd control efforts, whether it's other teams also. And that my understanding is that there's going to be discussions about what kind of a rules of engagement would be, what kind of things need to happen before something of that effect would be used individually.
So from the, like, scene commander, let's call them that, to whoever potentially might be coming out for crowd control, right? It'd be nice if that was reflected somehow, but maybe it's not here. I just want to put that out there. I think it's important to the community. So hopefully we'll be able to discuss that or include it in here. I don't know.
There's a directive that addresses crowd control and those kinds of situations that we have not reviewed.
Okay.
So that's probably the place to deal with it.
Yeah, okay. Philip?
Yeah, I just wanted to respond to V's comment. I've been thinking about what you were saying, and maybe this is just putting a thought out there. Maybe when a PPB shows up to a situation, whatever kind of situation, and another officer happens to show up in support of them, that should automatically mean that the officer then has to follow the PPB policy. Because in order to work together, because if they are separate, then it's out of their own jurisdiction, but they're working in the same area and they're coming together to work in that area. And so that the local policy should then kick in. What are your suggestions to that?
That's a brilliant point. I completely concur.
Okay.
I don't know
Now,
if we can write it.
Are we going to, are you proposing a friendly amendment to this policy? And if so, you have to ask the chair about that.
Could you restate it, please?
V?
Oh, no, I think it's Philip.
No, V, go ahead and try.
Okay, I'll give it a go. But Philip, please help if I need it, okay? So I would say to propose the recommendation with the friendly amendment of, let's see, how can I put this? If and when at a scene of the officer of the major jurisdiction, so in this case it would be Multnomah County, if that officer were to bring somebody from any other agencies, Multnomah County, I'm thinking of a sheriff, then the ruling policy would be PPB, would be of the PPB or something like that. Does that make sense? Philip, help.
I think you're good. Yeah, I mean, great. That was a great effort. You're awesome.
I think it's a little over the top. I think it requires might require some research to make a really definitive.
I think there is an intergovernmental
Yeah.
agreement
Yeah.
that's been signed by various police forces in the general neighborhood. And I think that before we try to stick that in some policy on pepper spray, we better take a look at that agreement.
Yeah, I think that's what we.
So more
thanks.
education on that.
So,
Okay, I'll
some
remove
research.
that from the amendment.
All right. Thank you, V. Any public comment on this?
I'd like to comment. I was in the WTO march in Seattle, and there was a considerable amount of pepper spray used in that march. And I'm curious if Portland knows and keeps transparent what's contained in the pepper spray, because it took a lawsuit and 10 years to get the actual ingredients of the pepper spray, and it was horrifying, some of the chemicals that they used in the pepper spray. So I'm just curious if that affected Portland Police transparency on what they're purchasing and what's in it.
Dan Handelman again. First of all, pepper spray has known to contribute to death, and actually Decky Dow's family received money from the pepper spray manufacturer because of that. And he was killed in 1998 by Portland police beating on him and spraying him. My understanding is that there's certain kinds of pepper spray where the propellant is flammable, and if a taser goes off near it, that can catch fire, and that should probably be addressed in the directive. My understanding too about the heat that you're addressing in here is that that'll be a officer safety issue as well, because I know this, when the pepper spray blows back on the officer's face, they do not appreciate getting the hot stuff they're trying to apply to the civilians, so it's probably better for them to have a lower heat as well. I do think you should hold off and talk about intergovernmental agreements and crowd control for those other directives that deal with those. And but V made a very good point that the prohibition against using this on vulnerable individuals that's in the other directives isn't in this directive, and you might think about adding that in here. Oh, and also, the Bureau has some canisters that are very, very large that I don't know what they did after this horrible incident, but they look exactly like fire extinguishers, and a police officer sprayed pepper spray all over a person who had set themselves on fire, and it must have been very painful because they died having that sprayed on them just before they died. So I don't know what the Bureau did to do that, but maybe this directive can address making sure that you don't confuse pepper spray and a fire extinguisher.
I just want to remind everybody that Oregon, the state of Oregon, has an obligation to the United States of America, to the federal government, to the Constitution of the United States. In the Constitution, we have the right to demonstrate. We have the right to air our grievances. We have the right to express our outrage. And it is outrageous to pepper spray children. It is outrageous to pepper spray into a crowd with families and children. It is outrageous. There is no excuse. There's no justification. It is outrageous. Demonstrations are a right of Americans. Americans demonstrating should not be sprayed with pepper spray, and never a child. Police officers need to beware of these directives. Do the right thing. You don't have to follow these directions. You're violating people's rights. They have the right to be safe. They have the right to air their grievances, to assemble peaceably. And they're met with aggression with police. This is directions. They're following directions. I understand that. But these police officers are going to start getting sued individually. Police officers, pay attention to what you're being directed to do. Don't violate my freedom of speech. Thank you.
Okay, Charles. Oh, I'm sorry, Charles.
Good evening, Charles Johnson. There's two issues. We've talked maybe more about the issue of what we should be talking about. Shouldn't be pepper spray. We should be talking about chemical weapons deployed against people. I don't know if crowd control in Portland goes to other levels of tear gas. I do know that within the last year, a police vehicle was misdeployed and a flashbang was used. I don't recall what pepper spray was used on May Day. But I don't want to lose sight of an important issue that Mr. Handelman raised, the death of Dickie Dow. We live in a weird situation where we have a lot of talk about pepper spray related to crowd control, but we're also very concerned with the rights of individuals and isolated and distressed people who might be subjected, or hopefully never will be subjected to pepper spray. I would really like to see the police department reiterate its case about the effectiveness and use of this temporary blinding agent. If there's any recommendation that you're maybe going to defer for further input, I notice even in the recommendations, it talks about additional study and development. I think considering the impact this has had on isolated and distressed individuals, and as Ms. Vanderlyn mentioned, ridiculous use to control citizens constitutionally addressing the shortcomings of their government, that we might defer this issue, and also that the COAB could improve its public engagement by pushing to work with the DOJ, the PPB, the CRC, the IPR, to really bring forth the Portland Convention on the Use of Chemical Weapons, because it's a chemical weapon. So consider that we might not need to approve this particular one until the community has a better belief in transparency and accountability, and vibrant discussion about if we can have abolition of this. Do the police really want to advocate that it's essential to their safety? Thank you.
Okay, thank you. We are at 8:30. I'd like to extend the meeting by about 10 minutes. Can I get that agreement?
Yes.
Okay.
I move to vote to extend until 9.
We won't need that long, but okay.
I just wanted to...
Is that a second?
Oh, sorry.
Second.
Is all in favor of extending the meeting till 9?
Aye.
Aye.
Opposed? Abstentions? I think we get it extended. I don't think it'll take us till 9 o'clock. I think we can wrap this up in a few minutes. V, you had something you wanted to say?
Yeah, I hear the community's concerns and a call for a Portland Convention on the on chemical weapons, and I think we should forego this this recommendation until then. So.
Rochelle?
I just wanted to mention that the subcommittee looked long and hard and argued long and hard about this, about prohibiting
Okay.
pepper spray.
I need to back up and ask me, was that a proposal?
Yes, Madam.
Do I have a second for it? Would you restate it, please, V?
I move to hold off on voting on this until the community created and held some sort of Portland Convention on the use and research of chemical weapons, and then weigh in on this particular recommendation. So that's it.
Is there a second for that? Second. Any discussion? Okay, I think we're about to lose our quorum here. What do we got?
Catherine.
Yep.
We've lost Mark.
Well,
Yeah, we don't have a quorum, right?
We just lost
Can I
number
just
8.
make a comment about
Okay.
this?
Yes, and then let Tom talk. Okay, go ahead, Rochelle.
I just want to say that the committee took this very seriously, argued about it for a long time. I was a proponent of eliminating pepper spray totally. And we looked into another jurisdiction that's done that, and that's New Orleans. And unfortunately, what's happened is, as a result of their not using pepper spray, their electronic control weapon use has gone up dramatically. So our concern is that we would be trading one weapon for another weapon. And so what we believed, I think, is that if we look into reasonable kind of pepper spray, if there is such a thing, with only the least amount of heat and the least amount of harm, we'd be in a better place than if we increased the PPB's use of electronic control weapons.
Okay, since we've lost quorum and we're over time, I'd like to take a few more statements and then let's close the meeting. Philip, then Rebecca, Hannah, then, Tom. Tom did have his hand up first.
Yeah. I think Charles, your comments are well made, as are some of the others. And Rochelle's correct. We did look at the elimination of pepper spray. And I will commit to the subcommittee going back and looking at that issue. And I don't know whether chemical weapons are part of another directive and whether there's an overlap or it should be looked at in terms of this directive, how best to do it. But we can't vote tonight anyway on it, so I think it makes sense to go back and look at what to do about it. But we were concerned about the option, and that is more people get tasered. So.
And I apologize for not engaging at the time that you were doing that hard work.
That's right.
I had a hand for Philip and then for Rabbi Kahana.
Yes, and thank you, Nancy. Is that Nancy with the green hat? Who was right to the point. Thank you so much. This subcommittee was very active, and I was one who was strongly against the use of pepper spray whatsoever. Like Tom mentioned, I was we wanted to eliminate it, but as Rochelle said, the unfortunate consequences were that the use of tasers has increased, and so if we do want to accept, let's make a friendly amendment further in the future, something to think about for now. We can say that we can eliminate the use of pepper spray with someone in a mental crisis or with children under the age of 18, minors that are involved, people who are vulnerable, things like that, where we can protect those people who are more vulnerable or frail visibly. And so this here, recommendations uses in general, population-wise. So that was my concern.
Rabbi Kahana?
Phil made my point.
Okay.
Thank you.
So what we have is a lot of input on this particular proposal, this particular recommendation, and maybe some work could be done to meet some of those requests or not, depending on the committee's bent and decision.
Yeah, maybe not. The word is we will be. We shall.
So I will entertain a motion for closing this meeting.
We can't vote.
Oh, that's right. All right, then I dismiss you.
Nice to see ya.
Meeting is adjourned. Thank you for your participation. Thank you for being here, for thinking, for talking, for helping to move this along.
Should we leave these here again? And